Hi, my name is Shreya Rajan, and today with us is Kanchan Gupta, founder, CADRE, that is an ODR platform, that is online dispute resolution, which is a online setup as an ADR that we know as additional dispute resolution. So, Kanchan, firstly, welcome. And before we begin with the interview with the business part, please tell us something about yourself. Let's go back to the beginning and how did you start your schooling, what all your school life consisted of, and everything regarding your childhood.
We were actually working with companies like Cognizant, where I started my career, who would give us their services. So I've seen both sides of the table when it comes to IT. And about 3 years of doing that, and then the whole entrepreneurial thing came back, saying that, look, I want to be able to do this for myself. If I have to spend uh, hours and mind space and effort and all of that, rather do it for a cause that's close to my heart. And we're kind of exploring a bunch of ideas when uh, you know dispute resolution itself came up. So I have friends who are lawyers who've been general counsels, and they've been working in companies long enough. They've done litigation. So I'd hear them complain about how it's difficult to find arbitrators, or how you have to still do piles of paperwork, and it's not transparent. So that's when my digital hat and my business hat kind of put to its started trying to understand where exactly the issue lies. So I'm talking about 2018. About mid 2018 is when we started kind of thinking about this. So started speaking to a lot of people, a lot of people already doing physical arbitrations or alternate dispute resolution methods. I taught myself the law as well as the concepts. Spent 6 months doing that, and that's when we said that, okay, there is definitely a solution to be built for this problem. And that's where I think Carter's philosophy comes in, where we say that it is neither a legal problem to be solved nor a tech problem to be solved. It is a problem, it is a real problem that needs a solution. Legal only gives the framework, and tech is the vehicle through which we solve the problem. So, that, and with that philosophy, keeping the users in mind first, using the user first, usability first principles thinking, is how we went about building CADRE.
So you knew about the legal problem that there was. You yourself are a technology person. So tell me, how is it that ADR and ODR are different? Like apart from the fact that ADR is a very physical thing. You have a face to face hearing and everything. People are sitting together, and ODR is a say like the same process in an online format. Apart from that, is there any difference in the legality or any other provisions or the laws that are complied with, or are they actually the same?
Uh, that's a very good question, and I think ODR is derived from ADR, if I may say so, right? So alternative dispute resolution methods were introduced, way back in the 80s and 90s, and even earlier outside of India when the ancestral laws came about, to ease the burden on courts and say that there are simple disputes that can be resolved outside court without having to take the uh, deep skill set of people associated in courts like judges and advocates. And that's how alternate dispute resolutions came about, right? And there are multiple alternate dispute resolution methods, starting from negotiation to conciliation, mediation, arbitrations. uh, and if you kind of break down, even the lok adalats are a form of alternate dispute resolution methods. So online dispute resolution only took this input that there are other ways of resolving disputes. And given that even groceries we are ordering online today, from our tomato, onion, potato, all those, to milk, everything is ordered online. So why can't dispute resolution be done online? Agreements are signed online, contracts are signed online, right? The world is thriving on email, SMS, WhatsApp, and the likes. So why can't dispute resolution be done online? If a loan can be given online, Why can't a dispute related to a loan be solved online? And I think that's where we kind of came about this, and that's how ODR came about, saying that, can we use technology, which is no more a luxury, it's a commodity nowadays. So can we use technology? Can we leverage technology to make this process simpler, it more fairer, more transparent, faster, cost effective? Because the older systems were still plagued by all of this. And I think CADRE's biggest differentiator lies in the fact that uh, we have uh, we have said that we have not taken the physical process and say, okay, let's convert this physical process to online. So if a physical process says that do step 1, 2, 3 requires a hearing to be done physically in a particular place, let me just convert that into a virtual room and do a hearing, right? And that's where our views and our first principles thinking came about, saying that there could be certain flaws with the physical process as well. There could be certain good things and not so good things with the physical process. So we kind of reimagined the whole process, saying that assuming that no physical process happened, the law has given us, this framework, which is the act, right? How do we make it an efficient process? And that's where I think online dispute resolution kind of not just is not just derived from ADR, but kind of takes it to another level, because you reimagine the process itself. And as you can understand, like the way you do things physically and the way you do things online, the behavior changes. The process itself can bring in more efficiencies. So I think that's what ODR is doing, in terms of, comparison with ADR. I hope that answers your question. I know I
Right.
went a little roundabout.
Yeah. So, since this is an online process, of course, we know that it's cost effective, time effective, and everything. But what is the approximate cost that, each case incurs, and how different is it from the actual ADR process?
So, in terms of cost, it brings down the cost significantly. To give you a very small example, uh, in a physical process, when we initiated a dispute resolution method with the parties, the other party needs to be sent a notice. That notice would be sent via India Post, right? So it costs to send an India Post, uh, a notice via India Post, and then you spend a week, 10 days, 2 weeks, whatever time, tracking whether it was delivered or not. All right. Even it was delivered, there is no guarantee the other person has opened and seen it. And many times it happens that the person on the other side has left that house and gone, not left another address, or they have refused to take delivery, right? So these are all things that add to the time and cost of resolving a dispute. Number one. Number two is, coming to hearings, trying to schedule, uh, a common point where three people at the least, right? The dispute resolution professional and both the disputing parties, for them to align on one place and one time to come to, you can understand what a scheduling nightmare that can be,
Right.
right? Or that it was. So in all probability, one of the three never ended up making it. All right. And that means that the time got extended, and time, if you say that the time value of money, right? So therefore, that also added to the cost. The third thing is the pile of paperwork. In the physical world, you're still expected to create like a 10-inch or a 6-inch pile of 5 copies of each document, and this copy and that copy, and create like this thick file of papers. You take away that's a significant reduction of, at least reduction of carbon print, if I may say, on this world. So we actually did run a campaign in our early days of Justice Needs No Paper as well. So if you look at these things, the costs come down significantly, right? From printing, postage costs to commuting and logistics costs for people to go from one place to another. right? These are all areas where costs come down drastically. The third thing is that, or rather the last thing is that when you come to an online process, it's all real time, right? You don't have to send something and wait. So we have leveraged technology in a way that we use digital modes of communication to communicate with the parties, whether it is email, whether it is SMS, WhatsApp messages, or voice calls, across multiple languages. So when you do that, then the person on the other side is getting real-time information, and they are able to participate using any one of those methods into the process. So the law actually provides for something called as documents only arbitrations, right, where you don't necessarily need hearings. And that was not looked at, or nobody had even considered that, until CADRE started talking about documents only arbitration, saying that we do documents only arbitrations. So that also brings down the time and effort significantly, because there's no need for hearing. The documentary evidence is more than sufficient to be able to resolve the matter.
Right. So, Kanchan, then what about cases that need fast, where the clients need you to fast track their cases? Suppose it's like the case is scheduled for a month from now, but they want it to be resolved in a week or 2 weeks. Then is there any additional cost, or you have the same price plans for everyone?
I'll just completely hijack this question, Shreya. And this is where there is a complete mindset shift. There is nothing like a case being scheduled, right? In the online world, it is not scheduled for a date. When we do documents only arbitration, the moment the case is put into our system, it has already started,
Okay.
right? Automated communications, automated dispute resolution has already started. So and because there are no hearings, there is no schedule. So we have been able to resolve disputes in as less as 30 to 45 days.
Okay.
Uh, and there is no need really for a fast track. Where there is a fast track or there is an immediate resolution required, so there is the provision. The law gives a provision of getting interim orders, and the parties are free to apply or request for an interim order, in which we can work on, which can be given within a few weeks of the claim getting logged.
Is right. So, since the process has started instantly, and of course, it's cost effective, time effective. But what about of course, ODR is a process where you mostly have domestic clients. I guess almost every client would be a domestic client because of the act that is in place. So, but what areas of laws are there that from where clients, most of the clients are driven from? Is it the banks and financial institutions, or is it like individual clients as well? And from which, like, if there's any particular state from where maximum cases are drawn?
Right. Uh, so dispute resolution, is it online dispute resolution? Number one, is applicable to any kind of dispute, right? Which under law, all disputes that can be arbitrable, online dispute resolution applies to it, right? So in that sense, from an applicability perspective, it goes across the board. Where do we get maximum amount of work? We clearly get a good amount of work from BFSI, that is NBFCs, banks, because they are sitting on a lot of defaults on their books. That's where we get a majority of our cases. In terms of the second set of cases, we get them from e-commerce is also is coming up very rapidly with the amount of disputes that they are getting as well, where customer service issues don't get resolved. The third category of disputes where we've been getting is from law firms and individual clients. So these are, as of now, few, but we see that there is a little progress in that as well, where two people have disputes, or two businesses have. It's a one-off case. It's not like a volume-based game. From when we're talking about NBFCs or e-commerce companies, we're talking about a volume-based game, right? We get 50, 100 cases per month, and so on and so forth. So we do get these one-off cases as well. Things like example being that there was a call center, there was a company that provided call center services, and one of the e-commerce companies had not paid up. So, these people had logged a dispute against them. So those kind of software development, services not the standards not met. Those kind of, single disputes we keep getting every now and then.
Okay. So, Kanchan, one very major issue that all of us are still facing and are wondering about is that ADR per se is a very private process, and it is mutually decided. Both parties mutually decide that okay, we'll go into arbitration. Okay, this will be the arbitrator, and whatever the process will follow. But in case of ODR, what we have is that one party goes to the ODR service provider, and then the service provider communicates with the second party. So how is it that this has changed? Because ADR per se is always known to be a mutually decided process. So how is like ODR different in this matter?
So, I'll just kind of go back to before ODR, how ADR was being done, right? And I'll take the specific case of arbitrations, because we do have a law for arbitrations right now. We don't have any law or policy for mediations per se, right? So I'll talk about arbitration specifically. Back in the day, the law says that a sole arbitrator or an arbitrator by mutual consent can be appointed for a particular matter. So if you look at agreements, right, look at terms and conditions on e-commerce sites, you look at loan agreements, you look at any other contracts between any two parties, a majority of them had this arbitration clause, which was to the tune of that in case a dispute arises, a sole arbitrator will be appointed by the company, right? And the other parties who don't read the fine print of agreements and terms and conditions have signed on to them, which means that this company had the power to appoint whoever they wanted. And in some cases that may have been misused in the past. So as a matter of fact, there was less transparency when there was no ADR or ODR rather, right? And what happened was in 2019 December, you may be well aware of the Perkins judgment that came and said that unilateral appointment of arbitrator is not the right way to resolve a dispute. So that put a lot of these companies under scanner, who would get one arbitrator to do hundreds of cases for them, right? And they didn't even ask the other party for consent. So to say that ADR accounted for mutual consent may, there is a certain, difference in that. Even then these clauses applied. How ODR is different is that I think one, that now you're not going to a person anymore as an arbitrator. You're going to an institution, right? Okay. And this institution has a lot of arbitrators on their panel, right? So therefore, there is more transparency. And because updates are real time, they are always available to you. There is no lack of transparency on how this process is going. Secondly, there is, at least at CADRE, we do take a declaration from every arbitrator before they start the process, which is a requirement by law, on, if they have a conflict of interest with the other parties. Thirdly, before the arbitrations itself begin, there is something called as the notice to arbitrate that is sent, saying that CADRE has been, chosen. They are registered under the Department of Legal Affairs. It is a neutral institution. If you have any issues, come back within so and so time. It's only when the other party doesn't come back within that time is when they go ahead and log the dispute. Until the time CADRE actually appoints an arbitrator, even this party doesn't, the party that's logged the claim also doesn't know who the arbitrator is. So there's only one person who knows who the arbitrator will be my case officer. Okay. Right? So as a matter of fact, there is more transparency in the arbitrator appointment in ODR than it was in ADR. And secondly, we see that in the last 1 year, we're seeing all the clauses undergo a change, right, in all these agreements, where it is being said that it has to be where institutions are being listed, and not just one institute, right? Saying that multiple institutes are listed, saying that, we could go to any of these institutes. And a lot of these institutes are registered under the Department of Legal Affairs. So therefore, I think it is also on the other party to show, certain cognizance and, go through the agreement, because they are all signing it, saying that, yeah, we are agreeing to this dispute resolution clause. So when they are signing an agreement, agreeing to a dispute resolution clause, they are already providing consent for that.
Okay. So, Kanchan, we are talking about, signing of documents and the process that, like the ODR process is. So, can you just briefly take us through the entire process from the, from commencing and from choosing the arbitrator, or from, the clients contacting the service provider to, the dispute resolution part, the final dispute resolution part. So, can you just take us in brief throughout the journey?
Yeah, sure. The journey literally starts with we getting a notice to arbitrate from the claimant. The claimant is the party that has logged the dispute, right? So we get a notice to arbitrate from the claimant, which is sent to the respondent or the defendant. Respondent or the defendant is the person against whom the claim is logged, right? So we are copied onto it, where the claimant is saying that, look, we've tried to get our dues back, but we haven't. So we are invoking clause number so and so in the agreement. And we are appointing CADRE as an institute to take this arbitration forward, right? Should you have any issues, please respond back by such and such time. To which CADRE then, acknowledges that NTA, saying that, yeah, we have received, and you will be kept in loop as and when the matter proceeds further. So assuming that the claimant gave a time of 10 days for the respondent to come back if they have issues. If they haven't come back, then they have a login to our platform. It's a web-based platform where they log in and they submit their statement of claim. Saying statement of claim in plain English is nothing but, what are the details of the dispute, right? So I lent so much money to XYZ. I followed up with them. They haven't paid. They've defaulted so much. And so on, the chronology of events essentially. And they upload any supporting documents, whether it is agreements, whether it is emails that they may have sent, or call records, or anything that they have to support their claim, they upload. Once that is done, then CADRE appoints a case officer to this claim. The case officer goes through the claim, goes through the attached documents, does a quick sanity check to make sure that everything is connected and in order. Right, it's not some different agreement and a different claim and so on. So they do like a quick sanity check. Based on the kind of dispute, then we do have a panel of arbitrators. The case officer writes into a couple of arbitrators, not just one. We take at least 2 or 3 arbitrators based on availability, based on experience, based on skills. Based on these criteria, we pick arbitrators and we write to them saying there is this dispute, and this is the declaration form. And if they would be willing to pick up that matter. And depending on where we get confirmation from, it could be from all 3, in which case my case officer takes the pick, or it could be only from one of the 3, then we take the pick, and the arbitrator is appointed online. I'll just take a step back now. So from the time the statement of claim is logged into our system, automated communication goes out to everybody, right? Both the parties, the arbitrator, the case officer, everyone. So automated emails go out, text messages go out, WhatsApp messages go out, and IVR based phone calls go out in a language of your choice. So we have currently about 10 Indian languages that we work with, right? And the tracking of all this communication is automatically updated back into our system, right? Whether an email was opened, what time was it opened, that information is automatically put back into the system. Similarly, SMS, was it delivered successfully? What time was it delivered? That information is automatic. So every communication that happens via a platform, there is a automated communication that goes out to parties and a tracking of that done. Coming back, arbitrator is assigned. So once the arbitrator is assigned, the case manager also uploads the declaration to demonstrate that there is no conflict of interest, and the arbitrator is in essence a neutral party. And at that point in time, the arbitrator first puts out their first order, where they basically are giving timelines to both the parties to get back. So they give a timeline to the defendant or the respondent, saying, please submit your defense by so and so time, and a timeline to the claimant to get back on that defense, and a final award date. Now, let's say that the defendant got a time to get back by 10th June, and it is 10th June and they haven't come back. So the arbitrator actually takes the effort to give them at least 2 or 3 more such opportunities to get back. In the meanwhile, the respondent and or the defendant is being bombarded by a lot of communication from our side, and we're able to track that, yeah, they have opened their emails. Yes, SMSs are being delivered. Yes, WhatsApp is being delivered. Some are even being read. Yes, they have picked up the phone call, right? So we are tracking, our case officer is tracking all of that information. Now, at the end of all of this, if the respondent still does not come back, then the arbitrator takes all the evidence that the respondent is actually aware that the process is going on and has deliberately not participated, and then proceeds for an ex parte award, right? The award is then published online. And once it is published online, we then send out a physical copy to both the parties. Now, in the event that the respondent starts participating, they can start participating in any form that they want, right? If they want to send a voice note, if they want to send us a handwritten note, if they want to log into the platform and participate, if they want to send an email, or any way that they want to participate, they can participate and submit their defense, and the system accounts for all of that. In exceptional cases where the arbitrator feels that the documentary evidence provided is not sufficient, is when they may hold a hearing. We've also seen that that's the process in the gist, and we've also seen that in many cases, because the amount of communication that is going out, nudging the people to participate in the process, we've also seen a lot of settlements happen midway.
Okay. So talking about settlements now, we talked about, enterprises and them having a contract and a valid arbitration clause. But what in cases of individual cases where, 2 individuals want to settle their dispute outside of court, and they might not have such an arbitration clause or anything in writing. So in those cases, what is the resolution in, the ODR scenario?
So in the ODR scenario, there are multiple things, right? So you have, one can definitely go in for mediation, right? We do have organizations, CADRE specializes in arbitrations. So you do have other ODR companies that do mediations. So you can actually start a mediation process online. But considering that mediation is a very soft, people kind of a process, so that will likely have hearings and, video calls and virtual calls and stuff. So that is an option that individuals have. If the individuals so decide, even if they didn't have an earlier agreement or contract, they can still agree to do an arbitration, even if it is by, the law says that it just needs to be in writing that, yeah, we agree to arbitrate. If they agree to arbitrate in writing, then an arbitration can be kickstarted even then, right? And then, of course, there are other methods like negotiation, conciliation. So all of this can be done even without an agreement.
Okay. And Kanchan, as we have discussed, and as is a fact that ODR is still, at a very nascent stage, and it's still a very growing phase. So, what do you think? How will it be able to compete with ADR, or how will it be able to get better than ADR in the upcoming years, or is it something that's always gonna be under the umbrella of ADR?
So basically, I don't think, or rather, I'm sure ODR is not in competition with ADR, right? ODR is just a simpler way of doing ADR, or a more efficient way of doing ADR. So if I have to rephrase your question, saying that our physical dispute resolution versus online dispute resolution, will physical dispute resolution go away fully? Not necessarily. There will be some cases where the value is very high, or where there is a certain necessity to have a physical hearing, where there may be a physical hearing. But largely the world has moved online. And COVID, if not anything else, has taught the world that we can all, continue to live and do meetings online and don't need to be physically present anywhere to get work done, right? It has been proven beyond doubt. So therefore, I think ODR is only going to simplify the ADR process, make it more efficient. They are not in competition.
Right. So it is basically like providing a platform to an already existing process. We can say that. And it is just like a facilitator that's enabling, better dispute resolutions with along with technology and, keeping up with the pace of the world, probably.
Yes, and the other thing is also that because it is online, and because we are able to market it better or talk about it better, uh, the awareness that methods like these exist, and I
Right.
think that awareness is growing and will grow multifold. When you talk about ADR to a layperson, or when I mention the word arbitration, nobody even knows, right? So today, if a landlord and a tenant have a dispute, the first thing they'll think of is, or the first threat you will give out is, I will take you to the court,
Right.
right? And I'm sure the day is not far when that line will change from I will take you to the court, that let's get into an arbitration and close this,
Right.
right? Where arbitration becomes a common word for every person to use, and is not just the it's not just a small community of lawyers or advocates or judges who know what an arbitration or a ADR is.
Right. So, Kanchan, talking about settlements. So, ADR is a very closed door process. But in case of ODR, do we also have, online recordings for the service providers record keeping? And how is it that, these recordings are not released to both parties? What kind of steps do service providers and especially CADRE takes to, keep this process a very private thing?
Yes, we have privacy policies, published on our website, and we do understand that this is a confidential process and nobody will have access. So every person involved with a particular matter can only access. So we have access-based controls we are being provided to the system. We use protocols for online security and confidentiality. So if you and I have a dispute, right, no third person can log in and see what is happening onto that, only you or I can do it. So we've provided those kind of access controls so that this information is completely secure. One is from a security perspective. Second is, if you were to compare it to the paper world, anybody can open a file and see it. You're sitting in somebody's office where there are a pile of arbitral cases, somebody walks in, can easily open the file. But here it is all saved online. There is no risk of destruction really, unless like a Amazon Web Services or a Google Cloud or something like that comes down fully. There is no risk of these files getting opened or lost or any of that. So the records are actually all the more all the more present anytime from anywhere. You don't have to physically be at any place. So that is in terms of availability. So we've spoken about security, we've spoken about confidentiality, and we've spoken about availability. And the last thing that I want to talk about is transparency. So when in a physical process, it is up to the transcribe. There may be something that's lost in translation because 2 3 people are talking, and who is transcribing that and what is being understood out of it. So when it comes to something like a documents only online arbitration, it is all there for people to see. There is nothing left to interpretation really. All right. So in that sense, it's completely transparent and fair process.
Okay, so again, Kanchan, now there's one thing that okay, these number of cases are coming up, but then there's another aspect that what is the success rate of these cases? So can you throw some light upon the success rate of ODR?
So I'd like to, before I answer that question, I want to understand what you mean by success rate. Do
As
you
in,
mean that are disputes getting resolved? Is that the
yes,
question?
yes.
Yeah. So in that sense, I would say that for CADRE, the success rate is 99.99% because all disputes get resolved,
Okay.
right? So in that sense, yeah, every dispute has a resolution. I think this question may be more relevant for something like a mediation, where it is not necessary that all disputes come to a logical closure, but with arbitrations, they all come to a closure. So
Okay.
uh, the only other metric that I'd like to add is about 15%, 10 to 15% of the cases that we get settled midway and don't even end up going through the end of the process. So
Right.
that is the additional success metric that I'd like to kind of add that wouldn't have been there earlier.
So that would be, CADRE's success that, of course, 99.99% is a high rate, I guess, be it for whatever process that there is. So that is a commendable thing. And one final question that I would, not a question even, one final suggestion that I would like to ask from you, Kanchan, is that, there are, obviously we talked about, the awareness part. So people who are not really very much aware about ADR, they are also hesitant about going online and taking up things online, so especially parts of their lives or whatever disputes they have. So can you just enlighten us with a few words to gain the trust and strengthen the trust of those people who still have trust issues and are hesitant about online processes?
Yes. To just give an analogy, 10 years ago, we were reluctant to buy clothes online or shoes online. As of today, everybody is doing that, right? There are successful companies built on the fact that you can buy clothes online or shoes online or other things online. So similarly, I think it's going to be a journey for online dispute resolution itself. The starting of the journey has to be aggressive awareness campaigns, because it is not like an e-commerce product. It's not like garments that everybody knows, right? The first level is even people knowing that something like this exists. The issue that we see is, at least in the individual consumer space, they're not even aware that something they have something like this that they can go to. The first step is actually running that awareness and making them aware that, look, you don't have to go to court for everything. Many individuals are actually discouraged from going to any dispute resolution method because they don't know that anything exists, anything outside court exists, right? So we want to be able to give a platform, or rather we are giving that platform to people, saying that no matter you have a 5,000, 10,000, 20,000 rupee dispute, we can solve it for you. Don't get discouraged. Don't write it off. Right? Which is what many people do as of today. So that is it. Once that awareness is built, the trust will automatically come from when they start seeing that, yeah, this is a transparent process. This is a process which is not biased. This is a process which is fast. This is a process which is giving me resolution. Sitting at my home, in the comfort of my home, from the comfort of a cab, from a phone, from a laptop, from anything, I can sit and resolve my dispute. It is Disputes are painful enough. Resolutions need not be, right? So I'm able to resolve my disputes hassle free. So I had a 10,000 rupees dispute from someone. I got my 10,000 rupees back in 30, 45, or even 60 days if you take it at a stretch. So I think once they start using the process, the trust will automatically come. For them to start using the process, awareness needs to be built.
Right, right.
And I think the journey has started. So yeah.
Right, of course. Now it is only now that, especially post COVID, I guess that ODR is even being talked about more, like
Yes.
more outside of the institutions that are already there, among the general public and among the legal fraternity for that matter.
Yes.
So yeah. Fine, Kanchan, that's it for today. Thank you so much for giving us your time and, enlightening us with your process, the entire process at CADRE, and of course, the concepts of ADR, ADR and ODR. So thank you so much for being with us.
Thank you for your time, Shreya.
Thank you.
And happy to be this and bring about that change in India, where we are able to take the burden of courts and make dispute resolution accessible to everyone and democratize this process. So
Right.
thank you for taking this to everyone. Thank you so much.
Thank you, Kanchan, and we wish CADRE all the best. May
Thank
you
you.
succeed, and may we keep seeing you going up and higher. So thank you for
Thank
your time. Thank you.
Best wishes to Legal Tech as well.